Okay, we're now streaming. Welcome everybody to this licensing hearing in relation to Silverstone Brewery. Could I invite a proposer for a chair, please? You're on mute, Jake.
I propose Councillor Andrew Kilbride as chair.
And could I have a seconder?
And I second that proposal.
Okay, thank you very much. Councillor Andrew Kilbride has been appointed chairman of this licensing subcommittee hearing. Over to you, Chair.
Good morning, everyone. Thank you all for attending. First off, is there any declarations of interest, please?
No, Chair.
Oh, Jake?
No, Chair.
And none from me. Thank you very much. A little bit of housekeeping. Can we just ensure that our mobile phones are all switched to silent or off, please? And that's all people taking part today, if you'd be so kind. And just a quick introduction of each of the members is so I'm Councillor Andrew Kilbride. I'm chairing the meeting, and if I can just ask everyone else just to advise who they are, please.
My name's Councillor Keith Hollender.
I'm Councillor Jake Roberts.
Licensing Officer, Enforcement Officer Charlotte Lindop.
James Chadwick, Solicitor Legal Advisor to the subcommittee.
Richard Woods, Democratic Services Officer.
Thank you very much indeed. Right, straight into it. Have all parties received a copy of the agenda for today's hearing?
Yes.
Yep. Okay, that's great. I'm seeing no one say anything. Have you all seen a copy of the procedure that the subcommittee will be following today? And are there any questions or issues that anyone wishes to raise regarding the procedure? Everyone okay with that?
Yeah.
Fantastic. So we're here. So are there any preliminary issues that anyone wishes to raise at this point? Anyone got any questions at this point?
Do I speak up now or after I've done my report?
This is just preliminary issues.
There's on the call is Mr. Charles Smith, who is the lead petitioner, and their written objection is included in the bundle. Unfortunately, he was unable to respond to the notice of hearing in the time I had asked for. So we ask the committee, it is your decision whether you allow him to address you or not later on this morning.
Okay. And in that case then, members, do we allow that to happen? Sounds like it's a little bit late in the day, but what's the members' feeling? Keith?
I think in the interests of transparency, we allow it.
Okay. And Jake?
Absolutely. In the interest of transparency, again, I would go with that. We should allow.
Yeah, and I'd agree with that. I would just say going forward, it's always best to get these pieces of paper in well before the date. People bear that in mind for future stuff. So yes, we'll allow that, Charlotte. So this hearing is in respect of the aforementioned application for the licensed premises. I'd like to invite licensing officer now to introduce the report. Over to you, Charlotte.
Thank you, Councillor. So to consider, the purpose of this report is to consider the Licensing Act application for a new premises licence to be granted in respect of Silverstone Brewery, 5 High Street, Silverstone, NN12 8US, and to determine said application. 5 High Street, Silverstone is currently an unlicensed premises and used to be a post office. An application for a premises licence to be granted in respect of this property was submitted by Mr. Timothy Coleman on the 10th of August 2021. The application is to licence the building for the sale of alcohol for consumption both on and off the premises between the hours of 8 AM in the morning and 11 PM in the evening, Monday to Sunday. The redacted application can be seen at Appendix 1. In considering the representations received and what is appropriate for the promotion of the licensing objectives, the steps the subcommittee can take are outlined in paragraph 6.2 further down in the report. When an application for a premises licence is submitted, the applicant must display a blue notice at or near the relevant premises and advertise the application in a local publication no later than 10 working days after submitting the application. The consultation period runs for 28 days from the day after the application is received. This gives the interested parties and responsible authorities the opportunity to make representations in relation to the application. The requirements for publishing and advertising this application have been complied with. The responses from the responsible authorities were as follows. Child protection, no response. Planning permission is required for when consumption of alcohol takes place on the premises. Environmental protection, no objection. Fire, no comment. Health protection, no objection. Local health authority, no response. Police, no response. Public health licensing, no response. Secretary of State, no response. Trading standards, no response. The council have received 3 relevant objections in relation to the application, one of which is a petition signed by 15 residents, including the 2 additional objectors that were also submitted separate representations, which can be seen at Appendix 2. The council also received 14 representations in support of the application, and these can be seen at Appendix 3. All relevant parties have been invited to attend the hearing. Mr. James Laband is here on behalf of one of the objectors who couldn't make it in their own right. Planning permission is required for when the applicant wants to sell for consumption on the site, and the applicant is aware of this. At the end of the consultation period, the licensing authority must hold a hearing if relevant representations are received, unless the authority, the applicant, and each person making a representation agree that a hearing is unnecessary. It must take such steps as it considers appropriate for the promotion of the licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. The steps the subcommittee can take are to grant the licence subject to the conditions as appropriate if it is considered necessary to promote the licensing objectives, exclude a licensable activity, refuse to specify a person named as the DPS, or reject the application. There are no financial implications arising directly from this report, and this was checked by Mr. Robbie McRobbie, Finance Business Partner. The decision, legal implications, the decision must comply with the relevant premises licensing legislation, statutory guidance, and the council statement of licensing policy. Any action taken must be necessary and proportionate in order to promote the 4 licensing objectives only. Any party has the right of appeal to the Magistrates' Court against any decision made by the subcommittee in relation to this application. These comments were checked by Mr. James Chadwick, Senior Licensing and Litigation Solicitor for West Northamptonshire Council. The wards affected are Silverstone, and that concludes my report. I think you've all have access to the appendices that were attached to the report. Thank you.
Thank you very much indeed, Charlotte. We're now going to hear the presentations from each of the parties. All parties will have an opportunity to make their presentations later in the hearing. At the end of each presentation, you will get an opportunity to ask any questions that you'd like. Please keep questions on what you've just heard, if you could, please. So, without further ado, I'd like to invite the objectors to make their representations now, please. Who would like to kick off? Are the objectors there?
Yeah, so I'm Tom Watson. I'm happy to kick off if that's okay.
Please do, Tom. Thank you very much indeed.
No, all right. No, thank you very much for your time. So I think pertinent to this licensing application, the primary concern, the basis of my objection was around public nuisance, in particular the potential for noise and disturbance given the sort of time running through till 11 p.m. This property is situated within what's typically been quite a quiet residential cul-de-sac that my property and some of the others resides within. We hear people come and go. Periodically, someone might have a few friends over, have a house party. You know, that tends to be fairly noisy, but it is by definition periodic. My concern over this is the concept of on-premise alcohol consumption, i.e. in a sort of a bar type setting within that residential cul-de-sac, with people sort of coming and going through till 11 p.m. every day. It is very difficult to conceive of how that wouldn't cause substantial levels of noise and disturbance. We get up very early to sort of head off to work every day, and effectively it's just there is a real concern over what that will do to the sort of dynamic within what has typically been a residential cul-de-sac. Having a post office previously might have been one thing, but that's very different to have sort of, running through late into the evening, people coming to a premise to consume alcohol and all that would typically go with that. So that is the key grounds of my objection.
Thank you very much indeed. Is there any other objectors who would like to comment now?
Yeah, I will, if I may, James Laband.
Please do, James.
I'm speaking on behalf of Karen Fanning, who lives at number 8 the High Street, which is directly opposite the premises seeking the application, being number 5. Karen herself is saying that living directly opposite these premises on the narrowest part of the High Street, where it's not even possible for 2 cars to pass. This demonstrates how close the houses are to each other, and it's going to give her sleepless nights. She gets up at 5:30 in the morning to conduct her work, and that's going to be broken by people making noise, drinking out in the street, and what's going to happen with parking is another issue, because there is no parking available for this proposed premises. So basically, it's public nuisance is the main objection that Karen has to this application. I'd like to speak further later on in the hearing, if I may. But that's my main point for now.
When you say later on in the hearing, I mean, can you not say what you need to say now?
Okay, well, bearing in mind that the unique geographical layout and close proximity of surrounding residential properties is highly relevant to this licensing application, and by granting the licence in its current form, it will undoubtedly greatly impact on many local residents' lives. Has any officer from WNC made a site visit or not?
Can I respond?
Yes, please.
So whilst we haven't visited as a result of this application, there was a temporary event notice submitted over Grand Prix weekend for the same premises, and we did visit over Grand Prix weekend.
Was there any visit made to the rear of the premises into the cul-de-sac where Tom Watson lives?
No.
This is highly relevant to the application. Therefore, I would suggest that a thorough examination of the detailed facts have not been made.
Okay, we're listening to that.
And I would just draw WNC. No, I'm not even going to say that. No, let's leave it there for the moment. Thank you very much indeed. Thank you, gentlemen. Thank you, ladies.
Thank you very much.
Mr. Laband.
Yes.
Could I just confirm the full name of the individual that you are objecting on behalf of in the first part of your submissions?
Yeah, I'm objecting for Karen Fanning, number 8, the High Street, Silverstone.
Fanning. Okay. Thank you very much, sir.
Thank you.
Thank you. Any more objectors?
Yes, it's Charles Smith, the lead petitioner, on behalf of the 15 residents who are all immediately adjacent to or in the vicinity of the property. My comments would certainly echo that of Tom and Mr. Laband's, in that in discussing and asking questions of all the residents in the area what their primary concerns were, the level of objection surrounding the consumption or a license to consume alcohol off premises between, say, the hours of 9 and 6 p.m. were very, very low. I would say to the point of there were no objections or concerns with a license being granted for off premises consumption or nothing substantive, accepting that there were other concerns and issues that residents had, but I do recognise that they are planning issues, not issues pertinent to this licensing committee. However, the level of objection and concern around a licence being granted for after 6 p.m. and particularly for consumption on premises was unanimous and very, very strong. And whilst I understand there are letters of support for the premises, those letters of support at the moment range from anything from a cafe through to a bar. And I think part of the concern and issue that we have right now is obviously what is the applicant's plans for this building or this premises. So I would ask the WNC to consider restricting this license to 9 a.m. to 6 p.m. And for the granting of consumption of alcohol off premises, which I do understand from a discussion with the applicant is in his immediate plans. So that wouldn't be overly restrictive or burdensome on what his immediate plans are. If there was then further plans down the line for the requirement to consume alcohol on premises or consume alcohol further into the later hours, that could be dealt with via a separate application with more clarity and thought around it and more engagement with the local community, of which there has been none. So that is a very strong felt view of all residents in the area, both ones that had time to sign this by the deadline and ones that didn't. So in summary, I would ask the council to restrict this to 9 a.m. to 6 p.m. and for consumption off premises. And if that were the case, there would be no objections from everyone in the community. And I suppose to that extent, our representation would therefore be withdrawn.
Thank you very much. Anyone else from the objectors side there? No, I don't see no one. So just from that, are there any questions from the licensing officer at this point? Charlotte? No.
Can I just add, councillor, that it isn't standard procedure for a site visit to be made when we receive applications.
Yeah, that's noted. Thank you very much, Charlotte. Are there any questions from the applicant at this point regarding what's just been said?
Well, yes, quite a few questions or certainly comments, to be honest. I'll start with.
That will be great.
Sorry, Chair, it's James Chadwick. If we could just restrict this to questions, Mr. From the applicant, I would be, I think that would be more appropriate.
It would indeed. So
okay,
just questions, please.
Yeah, okay. Well, just on that then, if I'm not allowed to sort of comment on some of the things, there's a few things there which I feel have said and are perhaps misleading or misrepresenting things.
Just on the question.
So, yeah. But what I'm saying is, well, how do those get addressed? Because I don't feel it's fair that people just come out and say things which aren't actually, true or relevant. 1 second,
Mr. Coleman.
Misleading.
Just 1 second.
Mr. Chair, Mr. Coleman can make those comments in his submissions. If we restrict this to questions of the applicant, Mr. Coleman can then make his comments and feelings known during his submissions, providing these are evidence-based, of course.
Yeah.
But it's just literally any questions that you just want to speak to the objectors about at this point.
Yeah, I mean, I would say perhaps then to everybody, you all sort of mentioned how close you are to this property. You are a million miles away from what's already an existing licensed premises down the road, 100 metres away, called the White Horse. So, I mean, I'm not suggesting that I'm proposing anything of the like to the White Horse. Yeah, I'm asking my question. Yeah, I'm getting to my question. So, yeah, okay.
Okay.
So you've just interrupted my train of thought. Basically, well, what I'm saying is how often are you impacted by that licensed premises currently? And, what are you currently doing about it if you are being impacted?
I would say, commenting from someone as sitting at number 3, which is obviously on the high street, is the White Horse has very minimal impact to us because it has a self-contained, obviously, parking space. It has a self-contained area where people consume alcohol on that premises and then disperse in a number of different directions from there. That's a very different scenario here, where there's the potential for people to be consuming, obviously, alcohol on this premises at 5 High Street, which has much greater proximity to the area. And also, when all the residents purchased their properties around 5 High Street, there was no anticipated, or it wasn't anticipated that there would be a licensed premises in that proximity to the application. So obviously the White Horse was that the White Horse was a known entity at the time. Sorry, Tim, I'm answering your question. So I would say they're two very different scenarios, and obviously the degree of proximity is very, very different. And so that would be,
and I think to build on that from my perspective, I think the degree of proximity is clearly quite different. Actually, there is some periodic noise that emanates from the White Horse, and we thought long and hard about that before we moved in. Actually, my wife and I. And it's manageable, because periodically, if they have major functions there, for example, there is some noise. So that is something we deal with, that we cope with, that we're okay with, that is manageable. It is very different from then having a property within the residential cul-de-sac, sort of operating as a bar with people consuming alcohol on premise through to 11 p.m. We would see that as quite different, and something that we wouldn't want to put up with.
Okay. Any further questions at this point?
Well, other than it's not a cul-de-sac, and it is a self-contained unit, the same as the White Horse. So,
can we stick to questions, please? I think that was the ruling.
It was indeed. It was indeed. So, just on that, then I'll move on to committee. Members, do you have any questions at this point? Keith?
Chair.
Jake?
Nothing to add at this time.
No, I've got nothing to add myself. So at this stage, I'd like to ask the applicant to make their case now, please. So over to you, Mr. Coleman.
Yep. Okay. So my application for a premises licence has been made with careful consideration to the environment with which the premises is set. It is a long-standing commercial unit within what can be considered the central hub of the village, with a pub and a convenience store within 100 metres of the premises, as well as a local doctor's surgery down the road. It's basically the centre of the village. The licensing legislation provides for many activities to be conducted between the hours of 8 a.m. and 11 p.m. without the need for a licence. Obviously, the sale of alcohol is unique and it does require a licence, but I feel it's important to distinguish that the activity itself shouldn't be viewed as a greater hazard to licensing objectives, just that it requires controls to be put in place to manage the risks. Now, I've addressed each of the 4 licensing objectives within my application by proposing several measures to form part of the licence. Over and above this, I engaged with the police to establish a set of conditions to satisfy the specific police-related concerns, many matters which will be based on experience and go a long way to safeguarding many aspects of the licensing objectives. It's notable that no other regulatory authority has felt the application requires any further restrictions be imposed. The main application seems to be centred around noise, but there's no detail around what noise specifically and how and where it's going to be created. It makes it very difficult for me or anyone else to assess the merit of these claims and therefore establish any means to mitigate them. There appears to be an implied suggestion that the sale of alcohol will automatically generate noise, which I feel is a flawed conclusion and one that has prejudiced many of the views of the objectors. My application contains several measures for managing and preventing noise, and I believe they will be more than adequate in preventing any of the suggested disturbances that we've heard so far. One criticism that has been made is the lack of detail around the proposed use of the premises. Now, I can kind of see possibly why they might feel like this, but I feel like I've been as clear and transparent as I can, whilst trying to maintain a certain level of commercial sensitivity. Obviously, this is a public document, people can read it. There's a level of commercial sensitivity I want to maintain. The objections seem to wish to portray this image of a noisy drinking establishment. I think it's clear from the application what the intentions are, and I don't think any of the concerns emanating from this are warranted, basically. It's also been mentioned by a few people, why 11 o'clock, why every day? The main reason of this is flexibility. Demand fluctuates, businesses need to adapt. Having this structure ensures a business will have the best chance of surviving. I just have to refer to the 4 other licensed premises in the village as examples of this. They've all whom successfully operate with daily closing times up to 11 p.m, 2 of which go well beyond this, and as far as I'm aware, all successfully adhere to all the licence objectives without any problem. I can't find any reason within any of the arguments being put forward why my case would be any different. I've deliberately limited the application to 11 p.m. Because I feel it balances the business need for flexibility, but also being mindful of the surrounding environment that the premises is located, which has been put forward. Now, I know I don't have to justify my application, but I do feel it pertinent to explain the business need behind the application. Direct to consumer sales are becoming a lifeblood for small independent drinks manufacturers. The COVID outbreak has exacerbated an already difficult trading environment where price and volume represent significant barriers to trade within the supply chain. So having a means to directly supply to customers is therefore a vital route to market. It has other benefits like reducing transport costs, lowering carbon emissions, and also the ability for us to manage our own waste, which is relevant to a new deposit return scheme, which the government are going to be rolling out soon. It's already being implemented in Scotland. It's going to happen in England. It's very onerous. This will go in some way to help us achieve those goals. So in summary, basically, I believe my application to be both reasonable and proportionate for both the business and its surroundings. It's a proposal that has generated an overwhelmingly positive response from the village, despite what you may have heard, and further afield, and it will undoubtedly be well supported. The concerns that have been raised are not really born out of reality. They're personally motivated and exaggerate with the sole aim of preventing the licence being granted, and therefore I don't believe they fall within the scope of this process. Should any notional restrictions be placed on the premises, it will unreasonably and unnecessarily impact the operation of premises without providing any additional safeguarding of the licence's objectives. I'm committed to my responsibilities under the licensing legislation and wish to be judged on merit rather than speculation. I request, therefore, that the licence be granted without any amendment or further conditions imposed. Thank you.
Thank you indeed, Mr. Coleman. Charlotte, have you any questions at this point regarding that application?
No, Councillor.
Thank you. Objectors, are there any questions you wish to raise at this stage?
Yeah, I've got a question. Is the applicant's intention to operate as a shop whereby people buy alcohol for consumption off premise, or to run a bar whereby they drink on premise through until 11 p.m. every day? I think it's important that we understand what the intention is, and the word flexibility doesn't quite do enough for me in that sense.
I was referring to flexibility in terms of times and opening, but like I said, I think I've already answered this question. I think it's clear in the application, what I want to do. I mean, I've put in there shop. So do I want to open a shop? Yes, I do. Do I want to distribute my online sales? Yes, I do. Do I want somewhere for people to be able to drink on premises? Yes, I do. Do I want to be open to 11 p.m. every day? In an ideal world, yes, I will, because that means the business is doing really well and it's thriving and it's doing, and that's great for me. In reality, is it going to be open till 11 p.m. every day? Probably not, but I understand that it has the potential to, and that's why you're concerned. Like I say, that is what it is. That's what I've applied for. That's what I would like. I've not hidden that fact. I make no apology for it. I mean, the image that's being presented, that being open to 11 o'clock is just going to have drunks sprawling out every night, causing news and nuisance, I feel is absurd, really. I mean, it goes against every licensing rule to have disruption and noise caused through licensable activities, because you put yourself at risk of losing your license. So it's sort of it's self-policing, really. I don't get this this focus on worst case scenarios, because these things, of course, they can happen, but they won't happen for very long before they're put a stop to. At the end of the day, where are all these rowdy people going to come from? That's what I'm struggling to understand. We've got 3 other licensed premises for drinking on site in the village at the moment. I live in the village. I don't experience any issues with what's being suggested could potentially happen here. you know, it's a village environment. I'm expecting village people to be the customers of this premises, and I'm expecting them to, you know, respect their own neighbours in doing so, as I'd expect, like, everyone to, you know, everyone to do the same.
I'm just going to nip in here now.
Yeah, so I'll finish that. Thank you.
Is answer the question.
Yeah.
I think you thoroughly answered that particular point there. Anything else from the objectors who wish to raise a question?
Yeah, if I may, Mr. Coleman suggests that he would like villagers to utilise the premises, but I would suggest that many of those villagers live too far away to walk to the premises. Is there any suggestion as to where these villagers may park, as there is no parking such as they have at the White Horse? I
think that's a planning issue.
Yeah, that's
okay. Right, fine. Well, we'll do that at planning then.
Yeah, that's for a different committee.
Sorry, sorry. Two questions, and if I may note, I am trying to keep this objective and without personal motivation, as may has been insinuated. One question comes to mind. So obviously this property is directly adjacent to or connected to two other properties. One where this commercial unit, as was stated in my representation, is physically connected to the master bedroom of one of those properties. I would ask, what is the applicant intending to do, or how is the applicant intending to reduce the disproportionate or potential for disproportionate noise and nuisance to that applicant in that adjacent property with his activities? Because clearly that is they are someone who is at the greatest risk of harm to potential noise. I point the council to the fact that was before a sorting office with some fairly quiet machinery in there, and that caused noise complaints at the time. So I just like to ask what's the applicant's plans for that and preventing that noise. And my second question, whilst I accept that we're not going to have raving revelers coming out at 11 o'clock at night, but what is the applicant intending to do to restrict the noise of people exiting the property late in the evening if they were to consume alcohol on premises? Because that is still an occasional issue that comes from the White Horse with people walking up, as you referenced, but that will be an issue that is exacerbated by this property. So what extra steps could he or would he take there?
Okay, well, I'll quickly answer the first question, and the second question seems it's fresh in my mind. I put in my application that obviously I'll be putting notices up by the door, just ask people to respect the neighbours and leave quietly as they leave the premises. That's commonplace in a number of establishments. It was something that I proposed, and the police also made a proposal on that regard. So you know that's point number one. You know, being realistic, you that's as much as you can do, isn't it? Remind people to be quiet. I mean, like I said, I'm not intending to get people, well, sound like a broken record. How often does this happen up and down the country, where people walk down the street shouting and waking people up? It's like I say, you're conjuring images of things which aren't necessarily really going to happen. And
I would assert that it does happen today from the White Horse, from people walking up the high street. So I'm just asking my question was perhaps to clarify is, what additional steps other than the nominal sign on the road are you proposing to take to help reduce that noise? Because considering that is the primary concern of the people who have signed this objection, and considering this is there is a unique sort of cluster of residential properties that are in close proximity, seven of those properties, bedrooms being very close to master bedrooms, being very close to this applicant's address. So I'm trying to give you the opportunity to say we would do these extra steps to really make sure that we reduce that impact and noise, because that is a genuine and legitimate concern, and perhaps a sign isn't enough. So that's what I'm just asking is, are there extra steps that you would take to reduce that potential harm?
Well, like I say, that is an extra step. That is an extra step taken, is by putting the notice up to remind people telling people as they leave, if you feel like there's a risk of it, that will obviously be done. You know, I just have to refer again to the police conditions. That's something that they feel is all that is required. If you know, if it helps, I'll make this commitment to you. I'll engage with the White Horse and ask them what measures that they take currently to help them prevent this happening. Because obviously, you know, if there's something there which we can learn from, absolutely no problem in implementing that. And perhaps you might want to suggest some things that you can consider then, as to what could be done. I'll happily take those on board and consider those. Perhaps you've got some ideas.
Yeah, well, my assertion would be is restrict the license, but you know that's where we'll disagree. No, but that's fine. That's the reason this process.
We need
no more questions,
now, gentlemen. I think Mr. Coleman's answered the question. Have you got any other types of question?
None from me.
Any other objectors?
No, none from me.
Sorry, Chair. I wasn't entirely sure if Mr. Coleman addressed the first question.
Oh no, I didn't. No.
Sorry.
Yeah, allow me to do that.
Thanks.
Just remind me, it was to do with
So
behind that joins on, isn't it? Yeah. Well,
yes. So number 1B.
Yeah. Well, I have spoken to the residents there, who obviously have expressed their concerns to me. However, the fact that they're not here today sort of supports what I'm about to say, is that they sort of not really wish to pursue that with me, to be honest.
Can I? Sorry. Can I?
Right.
Sorry, I have.
Everyone, just stop 1 second. Charlotte, can I just bring you in, please?
Yeah, Tim. Just so you know, because it's a petition objection, only the lead petitioner gets invited to the hearing. So it is.
Oh, okay. That's fair enough. That's fair enough.
No rating whether they're here or not. It doesn't mean that they're any less interested in the outcome.
Okay. Well, my point still stands that I have spoken to them anyway, and they've not suggested that is going to be a problem for them any longer. Their main concerns was that there was going to be sort of external matters which I sought to clarify, which seemed to satisfy their concerns, which, you know, I've spoken to them in person about, and you know, they've told me that they have no issues. So the fact they're not here today, I wasn't aware that wasn't because they couldn't be here.
Chair, can I just ask that the question is not answered by saying it's a non-issue, because as a matter of course of fact, that's not the case. As the lead petitioner, that is a concern of theirs. It is a major concern of theirs, and it is one of their primary concerns. The outdoor space no longer became a concern because the application was changed. So if I could ask that the question is answered, what steps will be taken to reduce the impact of noise on that master bedroom that is adjacent to the commercial property, it would be appreciated.
Okay. Well, if it needs to be addressed, I mean, the application itself is limited till 11 o'clock at night, and I think that goes a long way to eliminating any problems with noise. I mean, you can't eliminate noise. I'm not anticipating there's going to be excessive amounts of noise anyway, but you know, the licensing laws are that, you know, pretty much it defines late night as beyond 11 o'clock. So therefore, anything up to 11 o'clock is not considered late, and therefore I feel like as long as the noise is, it's not going to be noisy, but you know, noise is of a reasonable level, that is acceptable. And
so no.
Yeah,
so,
again,
so,
I'll
so
ask
no,
you the
so
question.
no.
If you feel like there's something that needs to be done, then come forward and suggest it. Just to say that you can't do something because this, that, or the other is not really helpful, and it's not really what this process is about. We're here to sort of establish how this premises can operate within the licensing objectives. You know, I've made my case forward. Pardon?
I'm just going to jump in there, Mr. Coleman. I'm just bringing in Charlotte. I think, Charlotte, if we have undue noise controls, I think going forward, you know, if the premises was really noisy, we could monitor that, couldn't we? And
yeah, I mean, the standard Sorry, Councillor.
Standard thing, isn't it?
Yeah. So if the council were to receive noise complaints, they would usually go to the environmental protection team, who would then instigate the standard noise monitoring procedure, which, you know, it's not my area of expertise, but would generally, from what I know, would involve the residents that are affected by the noise using a specific app to record and monitor the noise that then gets submitted to the council for analysing, and then the process continues on from there. And eventually, if deemed required, then a review could be called of any licence further down the line if it's deemed to be a significant statutory nuisance.
That's where I feel that this is going, Mr. Smith and Mr. Coleman. I think if it got excessive, you report it, and then the council would step in. Okay?
Yeah,
I think it's fair to say to a premises that you can soundproof every wall, because that's not feasible. So
I do understand that, and I do appreciate that. As you say, it's a unique scenario where it happens to have a master bedroom and some history and precedence of noise complaints. So hence why I thought relevant to raise today. But I do also take the council's point that it may well be a case of, I think as we're saying here, suck it and see from a noise perspective, if that's the route the council is going.
Thank you very much indeed. Have all the questions been answered now, Mr. Coleman?
I believe so, yeah.
Yeah, that's it. Thank you very much indeed. So there's no further questions from objectors, just to confirm?
No.
Excellent. Thank you very much. Committee, any questions, please? Keith?
Just to confirm, the back of the premises will be a storeroom up the steps, is that correct, Tim?
Sorry, say that again, sorry.
So on the site plan, back of the premises, you've got a toilet and then up steps up to a back room. Is that correct?
Yeah, I mean, it's probably hard to tell on the plan, but the room that you're referring to, which is the one that backs onto the neighbouring property, is with the shared wall, isn't really big enough for use in terms of I mean, it's likely to be a storeroom of sorts, because it's not big enough to sort of contain people within, if you like. It's sort of standing room, really. There's no way you can get any tables and chairs or anything of any note in there. So, again, without wanting to sort of say for definite, in case I'm held to it, it's unlikely to get used for any sort of noisy activity, should we say.
Okay, thank you.
Thank you. Anything else, Keith?
Nothing more, Chair.
Jake?
I think I've nothing really to add. Just to confirm, the White Horse pub is what, 100 metres away from this? Yeah. Okay.
Yeah.
That's all.
I've measured it.
Thank you.
Obviously.
Okay. Thank you very much. I don't have any questions, so I'm happy with what I've heard so far. So now we'll just move to the opportunity to sum up. So all parties will have the opportunity to sum up now, and you don't need to repeat your presentation in full. Just a paragraph or so, just to round up and to sum up. So can I ask the objectors, please, to sum up? And then just before that, have you had sufficient time to speak to the subcommittee as well? If you can just include that as well, please. So who would like to sum up?
I'll go first then. I'll go first. Yeah, I've had enough from the committee. I would just sum up by saying that the objectors are people that are going to be greatly affected if this application is passed. The supporters are people who are not going to be greatly affected by living anywhere near these premises. And I would suggest, as Charlotte has already stated, the great support for this application has come from a number of people in the village. And as Tim has suggested, a great support has come from a number of people within the village. But I would guarantee that if you look at these people on closer inspection, none of them live near the property concerned. So that's rather unfair to say that there's a great deal of people who are in support and there's people who object, because there's a great difference in the logistics and the dynamics of the geographical position of those people. That's really it from me. Thank you very much indeed.
Thank you. Anyone else from the?
I suppose just to sum up, from a to add to what Jim or James has said, as I say, the concerns held are specifically around those hours of 6 p.m. to 11 p.m. I accept the applicant's premise that from a licensing perspective, 11 is deemed late, and there are obviously additional restrictions. There is a unique residential dynamic here that I do think needs to be taken into account, particularly with the fact that you've got 5 to 7 residents whose bedrooms are in very close proximity to the application or to the applicant's address. We're not suggesting here that the applicant is going to be irresponsible and start having revelers and things like that. I think it's just the case that we are dealing with a baseline that starts from such a quiet position that any noise or potential disruption would be potentially disproportionate. But our preferred position here would be that obviously that the application is restricted to 6 p.m. But obviously respect the council's position ultimately on that. And as you say, there are recourses if it does go a different way, which obviously we would consider in due course.
Thank you very much. And do you feel you've had enough time to speak to the
yes,
committee?
I do. Yes, thank you. Sorry.
Thank you very much indeed. Mr. Watson, did you want to sum up?
Yeah, so I think in summary, the concern is having on-premise consumption of alcohol late into the evening would cause, in my opinion, significant noise and disturbance. That is borne out by the fact that, as I've said, you might periodically get the odd sort of house party or birthday party where there's people gathering to drink alcohol, and is very much audible within our residential setting. So I think, as has been suggested, restricting the hours would be greatly welcomed. But yes, thank you for your time this morning, and I do feel I've had ample opportunity to raise any points or questions that I might have had.
Thank you very much indeed, Mr. Watson. Mr. Coleman, may I ask you to sum up, please?
Yeah, I think I've said everything I wish to say in my statement, and I'll try and summarise, but I'll probably end up just repeating it. But I've put together this application, and I have considered the environment it is within, and I feel like the measures that I put in place will satisfy the licensing objectives, and it will appease any of the issues that we've heard here today. I've said it before, I feel like I should be judged on merit rather than just what potential could be. Should anything, worst case happen, obviously there are things further down the line which can address that. So I just feel the whole process is self-policing, and it doesn't need any further influence placed on it. In doing so, you're just going to harm the use of that premises. It's been sitting empty in this village for many number of years, and I do fear if there's any restrictions placed on my application, it's just going to prevent anything else being able to sustain itself in there in the future, and it'll be a great shame, a great loss to the village. There's a lot of support for it. Okay, there's a few minority who are around there who have concerns, and obviously I fully understand those concerns. I understand that they're feeling threatened by, having things change. But it's a commercial property. It always has been a commercial property. It needs to be put back into use. My proposal is to do that and make a thriving business out of it. I just feel I hope I get the opportunity to do it, basically.
Sorry, Chair, point of order here, and I think this is an important point. The applicant's address, or the unit that we're referring to, is a residential unit at present. It was historically a commercial unit. It was recently granted, basically was converted from commercial to residential. Planning would have to be sought to be converted from residential back to commercial.
Yes.
If I may just speak there, actually, it is inaccurate, but obviously it's irrelevant today anyway. Yeah.
Yeah.
So.
Everything will be subject to planning anyway. Mr. Coleman, have you had enough time to address the committee?
I guess so, yeah.
Good stuff, thank you. Can I just come to you, Charlotte? Do you feel like you want to sum up and have you had enough time with the committee?
Yes, thank you, Councillor. Obviously, you're reminded of the steps that you can and can't take, but I'm sure you're fully aware of those, so I won't repeat myself. The planning matters, as you said, are a separate matter. From what planning have said, it is purely the on-sale consumption that would require planning permissions, not the off-sales. And that's everything from me.
Okay, thank you very much indeed. James, did you want to just come in here and say anything on the legal side at this stage? Or are you happy?
Happy. The only things I would just again point out and reiterate from what's being said anyway, that this issue of parking for the purposes of the licensing objectives, that's not really a relevant representation, and obviously that's more of a matter for planning. And yes, just to confirm that if, as Mr. Coleman has said, if there are if any problems do occur, then there is always the possibility of any person concerned at that making an application for a review of the licence or contacting the environmental health section regarding a potential noise nuisance. So yeah, just to point out, other than that, Chair, I have nothing further to add now.
Thank you very much indeed. So the next stage is we'll all retire now to make our decision. If I can ask you to retire with us too, James, that'd be good. All parties will be communicated with the decision within the next 5 working days. It will be published on the website, and you have details of how to appeal against the decision if you need to as well. All that information will be published. So it is now at 10:52. I'd like to thank everybody for attending, and we'll retire now, and that's the end of this meeting here.